फ्रेंड्स, कैसे हैं आप सब? आशा करता हूं आप सब बहुत अच्छे होंगे। मैं अपने तहे दिल से आपका सुप्रीम कोर्ट केस लॉ राउंडअप सीरीज के तीसरे अध्याय में आप सबका स्वागत करता हूं। टुडे वी शैल बी डिस्कसिंग two case laws as held by the Honorable Supreme Court related to Section 147 of the Income Tax Act. Hi, this is CA Vaibhav Goel, and today we shall be discussing Marico Limited case and the NDTV Limited case on that issue. Please do watch my video till the end. Do like it, share it, subscribe it, and tag your friends. First, Marico Limited case. The case was completed under Section 143(3). Alright, before moving on to the facts, let's know what is the golden principles for invoking Section 147. That there must be a reason to believe. Alright, first principle. What is the second principle? The second principle is, if the revenue wish to invoke 6-year time limited period in a case where an assessment under Section 143(3) has been there, then true and fair disclosure on the part of the assessee is required. If there is a failure on the part of the assessee to truly and fairly disclose all material facts relevant for its assessment, truly and fully, so the assessing officer would be well within its right to invoke Section 147. So, Marico Limited case, the assessment was completed under Section 143(3), and the learned AO wished to invoke 147 within the 4-year time bracket. So, the second condition is not required to be satisfied. Here only the first condition, that is, there must be a reason to believe and not mere change of opinion, as has been held by the CIT versus Calvinators of India Limited case by the Honorable Supreme Court. So here what happened, that there was certain amortization of brand value. The query was asked during the assessment proceeding. The query was asked. The query was satisfactorily replied by the counsel of the assessee. However, the issue was not found part of the assessment order. Alright. So what was the revenue contending? That since the issue was asked, it was replied. However, this issue does not found its place in the assessment order. So it cannot be said that there has been an opinion on the part of the assessing officer, and since it is not an opinion, so there is no question of change of opinion, and we can fairly comprehend that there was a reason to believe on the part of the assessing officer. But what was the counsel of the assessee was saying? That irrespective of the fact that the assessment order finds, that the query finds its place in the assessment order, irrespective of the fact, the query was asked, it was satisfactorily replied, and the fact that this query and the reply of the assessee or the logic of the assessing officer to drop that addition did not find its place in the assessment order itself justified that there was an opinion or there was a framing of opinion on the part of the assessing officer. What opinion? That this issue does not merit addition. Had it been the case that the query was asked or the assessing officer not asking that query was asked, not replied by the assessee, or the query was not being asked by the assessing officer, then there can be a situation of reason to believe. But here the query was asked, satisfactorily replied, only fact was that this does not find its place in the assessment order. This will be very useful. Why? Because in our local towns, assessment under Section 143(3) or under 147 are very cryptic, meaning thereby they does not mention what are the issues involved, what were the argument. It is only this practice of speaking order. You can watch my video on scrutiny assessment where I have focused on principles of natural justice. So coming back to the issue, so this practice of speaking order is generally followed from CIT appeal and henceforth, not at the AO level, generally in small towns. So this was the case as well, that the order was cryptic, it does not find issue. So Honorable Bombay High Court said, we go in favor of the assessee. Why? Because the argument of the assessee is very well that this issue does not merit addition. Why? Because assessing officer has framed an opinion, and when he has framed an opinion by not including that issue in the assessment order itself is an opinion, and if assessing officer wants, अगर वो 147 इन्वोक करना मांगते हैं, it will be a clear case of change of opinion. तो ये क्या हुआ, मैटर एसएलपी के थ्रू ऑनरेबल सुप्रीम कोर्ट के पास चला गया. एसएलपी में ऑनरेबल सुप्रीम कोर्ट ने क्या कहा, ऑनरेबल सुप्रीम कोर्ट ने कहा, कोटिंग ए पैराग्राफ फ्रॉम द ऑर्डर ऑफ द ऑनरेबल बॉम्बे हाई कोर्ट, उन्होंने दैट they dismissed the SLP. So as per article 141, the dismissal of SLP assigning reasons is binding upon all courts within the country. Had it been mere dismissal of opinion without ascribing reasons, then it would have been only a judgment of a Bombay High Court. But here reasons have been given. Though doctrine of merger does not apply, it cannot be said that this is a decision of the Honorable Supreme Court. However, the reasons ascribed in the dismissal of SLP is fair enough to act as precedent under Article 141 of the Constitution of India. And if you wish to know more about the substantial question of law, provisions of Article 134A, 133, 136, kindly message me in the comment box. I will definitely reply. Now coming to the second case. The first case was decided in favor of the SSE. Why? Because there was a change of opinion. Now this is a case of NDTV India Limited case, the famous case. Please do like it, share it, subscribe it and tag your friends. और थोड़ा सा तो मजे लीजिए यार. Thank you.